a presentation on basically the updates that are going on with respect to federal law changes. I'm not going to cover a lot of state law changes because I know a lot of you are from obviously different states. We have a ton of changes, or a few anyway, that are occurring here in Oregon and Washington. And there'll be other opportunities, I think, where folks in different states can attend state-specific conversations. But this is what we're going to cover today. We're going to cover changes in the National Labor Relations Board. Particularly, I'm going to talk about the new Republican board majority, the new General Counsel, and then significant reversal of major Obama-era decisions. And for those of you who are in non-union workplaces, don't worry. There's going to be something for you in this presentation. So we'll get into that in a bit. We're also going to talk about significant employment changes in the tax reform law that just was enacted by Congress. We're going to talk about just a little bit about changes to tip pooling that are occurring at the by the Department of Labor. And that would be obviously of most interest to any of you out there that are restaurant or hospitality type employers. We're going to talk about the increase in independent contractors and what we call the gig economy. I'm going to mention a little bit about the EU General Data Protection Rule because I just want you to know what that is, and I want you to, kind of at least figure out whether it applies to you. If it does apply to you, it's a significant law that you need to start really gearing up for. And then I'm going to talk a little bit about what we think is what we think is going to happen in the future. What other changes is Trump going to, or is the Trump administration going to bring for employment law? So it seems like a pretty aggressive agenda, but I'm confident we'll get through this in our hour. Okay, so first we're going to talk about the National Labor Relations Board. And essentially, in the Obama era, of course, as a Democrat, he basically voted in or appointed members to the National Labor Relations Board that were very pro-union. So and it was typically a majority of Democratic board members during Obama's administration. So that board was extremely active, more active than boards in the past have been. And they took the opportunity to basically make sweeping decisions that really overturned years and years and years of National Labor Relations Board cases and changed basically cases that had significant impact on many employers. So it's not surprising that now that we have a Republican administration, they are going to do what they can to sort of right the ship, if you will, and at least bring some, I don't want to say normality, but some more sense of evenness and back into the case law that was there. So I think we've only seen the tip of the iceberg. I'm going to talk about what that is, but there are going to be more changes. So why should you care? If you're not a unionized place of business, why should you care about the National Labor Relations Board or the National Labor Relations Act? Well, you should care because there is a particular provision of the National Labor Relations Act, Section 7, that applies to most unionized and non-unionized employers. If you're particularly small and you don't have a lot of business that's involved in interstate commerce, you may not be, Section 7 may not apply to you, but for purposes of this presentation, I'm just going to assume that it applies to most of you and that most of you should be at least somewhat cognizant of this rule. Section 7 essentially provides that employees have the right to engage concerted activities relating to the terms and conditions of employment. So that means they have the right to discuss wages. They have the right to discuss their benefits. They have the right to bring gripes about those issues and any other issues that would be included in the terms and conditions of their employment, including supervisors that are nasty or overbearing or that they don't like. So there are all sorts of types of conversations that employees have about their employment. And we used to, think about this Section 7 conversations as sort of the water cooler type conversations. Those discussions that employees might have with each other over the water cooler when they've taken their break or whatever. So that's essentially Section 7. And of course, every word in a definition has, particular meaning in the law. So this says concerted activity, and it has to be protected concerted activity. So concerted activity is generally activity that includes 2 or more employees addressing their employer about improving work conditions and pay, or one employee speaking to his or her employer on behalf of himself or herself and one or more co-workers. So to be concerted, it has to be more than just one person complaining. It has to be a conversation between 2 people complaining, or it has to be one person complaining on behalf of others. So that's essentially Section 7, and we're going to get a little more into that. But I just wanted you to understand why you should care about what's going on at the National Labor Relations Board. So here are the changes at the board that I mentioned. The new Republican majority. Now, the gentleman that's the 3rd in here is just stepped off the board. He's no longer on it. His name was Niscamera, his last name, and he was one of the Republican minority members of the board when there was a Democratic majority, and he typically dissented in a lot of the cases that were decided that basically made those sweeping changes to the law. So the other folks that are listed here are William J. Emanuel, Marvin E. Kaplan. I don't think that Mr. Kaplan's presented there. I believe the first man is Mr. Emanuel. John Ring is coming onto the board, and the President Trump nominated him, so he's pending Senate confirmation right now. 2 other members of the board, Lauren McFerrin, who is the woman on the far end, and then Mark Gaston Pierce, who is the second gentleman in, are the 2 Democratic members. Each board member serves 5-year staggered terms. So Ms. McFerrin and Mr. Pierce's terms will be coming up to an end here shortly. Now, we'll never get a full, and neither should we ever get a board that is that has only members of one particular party. So President Trump will have to name people that are labor representatives to fill those other 2 slots. So the other change at the board, this is a pretty significant change, is that we have a new General Counsel. His name is Peter J. Robb. And Mr. Robb was appointed by the President to a 4-year term. He is independent from the board and is responsible for investigation and prosecution of unfair labor practice cases, for the general supervision of the NLRB field offices in the processing of cases. So he may give field offices instructions about what they should do or what they should be doing with respect to cases. He comes from a employment management-sided background and was formerly a partner with a management-sided law firm. Okay. Sorry about that. Go back to this memorandum that I've talked about here. Mr. Robb issued this memorandum as soon as basically almost right after he was nominated to the board. His memorandums are always called GC something, and usually the 18 is the year. So this is 2018, so that's why it's General Counsel GC 1802. I think it's the second memorandum that he's issued. This memorandum basically rescinded 7 advice memorandums issued by his predecessor, including the GC 3-15 guidance, which is a significant guidance, and I'll talk a little bit about that. But he basically rescinded those and said, you know, we're going to be issuing new guidances on this. So the GC 315 guidance, if you never read it, was issued on March 18, 2015. It's actually called GC 15-04. This one basically was a report of the General Counsel that discussed various handbook provisions and went through the handbook provisions and said why they are legal and why they're not legal. And they did this under the guise of a case that was issued by the Obama-era board called Lutheran Heritage Village, Livonia. I'll give you the site. I don't know if any of you care about that, but it's 343 NLRB 646, 2004. And this case basically said that the mere maintenance of a work rule could violate Section 7 of the National Labor Relations Act. And he said the most obvious way that a rule would violate, he calls it Section 8A1, is by explicitly restricting protected concerted activity, which we've talked about. By banning union activity, for example, and I'm just reading from the General Counsel memorandum, even if a rule does not explicitly prohibit Section 7 activity, it will still be found unlawful if employees would reasonably construe the rule's language to prohibit Section 7 activity. In other words, prohibit the concerted rights activities of talking with each other about the terms and conditions of employment. The rule was promulgated in response to union or other Section 7 activity, or the rule was applied to restrict the exercise of Section 7 rights. And it's that last or that they used to basically say that a lot of the handbook provisions were invalid. And I'm just going to give you a few. This memorandum is 29 pages long. So it goes through many, many handbook provisions that they found unlawful. But for one, the former National Labor Relations Board said that confidentiality rules in handbooks were unlawful. And so, like, for instance, they said, we found the following rules to be unlawful because they restrict disclosure of employee information and therefore are unlawfully overbroad. And an example of something they found unlawful: do not discuss customer or employee information outside of work, including phone numbers and addresses. And so that's just one example. This memorandum goes through many, dealing with confidentiality, dealing with unlawful rules relating to employee conduct towards the employer. In other words, unlawful, overbroad policies were, example, be respectful to the company and other employees, customers, partners, and competitors. Be respectful of others and the company. That was found to be unlawful. The reason it was found to be unlawful, it was because they felt that employees would construe those rules as preventing them from participating in Section 7 activity. So I don't want to go on and on about this. If you're interested in what the prior board did, you can look that memorandum up. It's been rescinded now, and so we're going to see, you know, basically I'm sure a lot of your counsel went through your handbooks and made changes to at least make it not overt against, like that there wasn't something overt that was unlawful in your policies. Whether you want to change those back or not is obviously a question between you and your counsel, but certainly, there's an opportunity to do that. Okay, so the memorandum that we've been talking about also provided a list of the previously issued decisions where Mr. Robb might want to provide the board with what he called an alternative analysis. And those included concerted activity for mutual aid and protection. That's what we've been talking about. Those are the Section 7 rights. Also, common employer handbook rules to be found unlawful, which we've been talking about. Rules prohibiting disrespectful conduct. Rules prohibiting use of employer trademarks and logos. Basically, that provision that he's talking about, use of employer trademarks and logos, was a way that the board found to overrule a lot of social media policies. Social media policies might have said, look at you, here are the rules about your behavior on social media as an employee of this organization. You can't, put our logo or trademarks out on social media. Another big rule was, thing was whether employees could post pictures on social media of themselves doing something that may not be something the employer, would like, when they're wearing a shirt with the employer's logo on it. So it was cases like that where the board said, well, wait a minute, we think that impacts an employee's Section 7 rights. So those cases are going away. Rules regarding employees maintaining confidentiality of workplace investigations. That was another place where we were really kind of hampered, and a lot of us just didn't even pay attention to that, quite frankly, because it's very difficult to do a workplace investigation without talking to witnesses, and it's very, what basically the board was saying was you can't tell witnesses not to that they can't have conversations about this workplace investigation with other people. But what that would do is it would hamper the investigation, because it's kind of poisoned the well, if you will. People would talk about what the questions were that they were asked and what they thought, and then the next person that came up, their opinion would be maybe different than it would be had they not had that conversation. So now we can go back to basically asking employees, look, please don't talk about this with other employees while we're performing the investigation. So those types of workplace rules that we all found to be sort of confounding are going away. The other thing that's going away is purple communications, in all likelihood. If you don't know what purple communications was a board decision that overruled a previous board decision called, actually out of Eugene, Oregon, called the Eugene Register Guard. Eugene Register Guard decision basically said that an employer could restrict an employee's ability to have conversations on email about union activity while they were at work, and basically say, this is our business computer, and you can basically only use this business computer to talk about business things. Essentially, I'm making it a lot more simple than the decision was, but that's essentially what it decided. And Purple Communications came in and said, well, wait a minute, you are affecting employees' rights to have concerted right activities. That's just how you communicate at work. You communicate with each other. And so, and part of that communication is over email. So we're gonna, overrule Eugene Register Guard and say that employers cannot have rules that restrict an employee's right to use their email system to engage in Section 7 activities. They can basically say you can only do that during, times when you're on a rest break, or, when you're not working. So that was basically Purple Communication. So expect to see a change there in the coming, months, if not maybe a year. Okay, so some of these decisions that I'm going to talk about now only affect unionized workplaces. Some of them affect both unionized and non-unionized. But what happened before Mr. Miscamera, who was the chair of the board, stepped down, and I think he stepped down close to the end of December, was that we got the two new Republican board members and Mr. Miscamera. So we had a majority of Republican board members on the board, and they went through and just had a spat of decisions that overruled really egregious decisions. When I say egregious, I mean, decisions that were very unpopular for at least management that were Obama-era decisions. So these are the decisions they overruled. They went back to the pre-Browning Ferris. Browning Ferris is a very, very instrumental, case that the Obama-era board decided. We're going to talk more about these. I'm just listing them right here. So this dealt with joint employers and what the test for joint employment was. Restoration of an employer's right to create and enforce civility rules. That's kind of what we've been talking about with respect to Section 7. This decision applies to will impact all employers. Restored stability after expiration of a union contract. That basically is going to affect unionized workplaces. The board returned to a community of interest factors for union election. Of course, that's going to affect unionized workplaces. Okay, so the Browning-Ferris rule. In the Browning-Ferris rule, the NLRB announced a new expanded standard for determining joint employment between two or more employers. The majority there ruled that a joint employment relationship could be established where an entity had the right to control. So the right to control, is not the same thing as actual control. So only where they had the right to control the terms and conditions of an employee's employment, as opposed to what had been the law for years and years and years, which required that an entity had to exercise actual control. So under the Browning-Ferris standard, joint control could be established where one employer had a contractual right to set standards for employees, even where that authority wasn't exercised. So imagine, if you will, a franchisor-franchisee situation where the franchisor has rules that says all employees and all franchises that we have to wear the same uniform so that everyone looks the same, so that it looks like one company even though they're separately owned franchises. Or they say, look, we want all of our hamburgers to taste exactly the same. So you have to follow these rules regarding preparing food. And you have to, this is how we prepare food, and this is, so there are franchises do have rules with respect to how their franchisees operate. And just merely having those rules created a joint employment standard in the franchisor-franchisee arena. And I'm not sure if you heard about all of the, especially I think it was McDonald's, had, some significant impact from overruling of this Browning-Ferris standard, or the pre-Browning-Ferris standard by Browning-Ferris. Okay, so applying Browning-Ferris, basically the NLRB imposed liability on companies that hadn't ever been considered a joint employer. And of course, there was immediate adverse reaction to that by companies and management-sided labor employment lawyers that basically said they were changed years and years and years of common law employment. So it's not surprising that the new you know, when we had a majority on the board, the first thing that they did was to find a case that they could use to overrule Browning-Ferris. And that case is called Highbrand Industrial Contractors Limited. And in this case, the new Republican majority ruled that a finding of joint employer status shall once again, and I'm just quoting from the decision, a finding of joint employer status shall once again require proof that putative joint employer entities have exercised joint control over essential terms rather than merely have reserved the right to exercise joint control. The control must be direct and immediate rather than indirect, and the joint employer status will not result from control that's just limited and routine. So that is the basically what happened on this case. Okay, so then, oops, sorry about that. The next case basically is a case that restored the union's right to create and enforce civility rules. And this case should be important to everyone because it applies across the board if you are subject to Section 7. So the board set forth a new standard regarding when an employee reasonably construes a workplace rule as impacting Section 7 rights. And just to give you a little background, the case I mentioned before, when we were talking about the General Counsel Memorandum, was Lutheran Heritage Village, Livonia. And in that case, the board held that employer who maintained a workplace rule that an employee might reasonably construe to limit the employee's ability to participate in a protected 7 concerted right activity would violate the National Labor Relations Act. And when they talked about reasonably construe, the board often said it chilled the right. So you may have heard your lawyer say that, or may have read it somewhere, but they would often say, well, this chills the right of the employee to participate in Section 7 activities because even though you don't think that it actually does limit their ability, they thought it did. I mean, the rule was overbroad because it wasn't phrased in a way that the employee could understand that it didn't impact their Section 7 rights. Essentially, the board again found a reason to overrule this, and that reason was a new case called the Boeing Company. And in the Boeing Company, the board basically overruled the reasonably construed prong and set forth a new standard that the board will now evaluate first the nature and extent of the rule's potential impact on the National Labor Relations rights, and second, whether there are legitimate business justifications to support the rule. So even if it does do the first, are there legitimate business justifications, which is a very common analysis undertaken in employment law. And so the board will continue now to evaluate workplace rules. So the board isn't just going to say, oh, well, we're not going to look at any workplace rules to determine whether they're overbroad. They're going to continue to do that, but the rule that they're going to apply to determine that is going to be a much less strict rule than was applied before. Okay, so the third case, the thing that the board did was basically to issue a decision that restored stability after expiration of union contracts. And basically, this deals with if a company has a pattern and practice of doing something at a certain time, for instance, changing, they may update their employee benefits at a certain time of year. And if that occurred after expiration of the union contract, could the employer do that or not? So the employer announced a new definition of past practice and held that employer's past practice constitutes a term and condition of employment. So, and I'm using the example of employee benefits plan, because that's the case that the employer used to overrule this, prior, more strict decision by the Obama era board. And the case that did it was the board case that they overruled was called EI DuPont Nemours, and the case that overruled it was called Raytheon Network Centric Systems. And the Raytheon case dealt with Raytheon company that basically was a union shop, and beginning in 2001 and continuing through the expiration of their most recent collective bargaining agreement in 2012, employees received healthcare coverage under an employer-sponsored benefit plan. And under the terms of that plan, Raytheon reserved the right to amend the plan, and this reservation was incorporated into the CBA. Then from 2001 to 2002, Raytheon made certain changes to the benefit plan without objection or request to bargain from the union, including an annual increase in premium. And during the negotiations for a successor contract in the spring of 2012, the union proposed eliminating Raytheon's right to make unilateral changes to the benefit plan and to provide that the terms of the benefit plan would remain the same for the duration of the contract. And the employer rejected those proposals. In the fall of 2012, Raytheon informed the union that, consistent with its past practice, open enrollment was about to commence and that it intended to proceed as it always had. And upcoming changes to the plan were communicated to all employees and implemented over the objection of the union in 2013. And then the union filed the unfair labor charge. Basically, the board, the newly constituted labor board, looked at this case, and they found this was an ability for them to overrule the DuPont case, and basically decided that certain section of the NLRA requires employers to provide notice and opportunity for bargaining prior to implementing any change in a mandatory subject of bargaining. But the issue for the board was to decide what constitutes change. So essentially, the board stated that nearly everyone would evaluate whether a change has occurred by comparing the challenged action to the employer's past actions. So basically, if you have a pattern and practice of doing something in the past, then that occurs after the expiration of your union contract, you're still going to be able to do it. It's going to be essentially considered a term and condition of the union contract. Okay, so the last of the 4 decisions that the board just recently, and we're talking December 2017, issued was one that returned to the community of interest factor for union elections. And so essentially, this decision struck down the ability of unions to use micro units in union organizations, and the board returned to the prior standard of determining whether the petitioned-for employees shared a community of interest sufficiently distinct from employees excluded from the proposed unit to warrant a separate appropriate unit. So those are the 4 cases, and that's a pretty significant start to to the new kind of what we would call first year after, and really it was about the first year after Trump became, or we have a new Republican administration. And we'll continue to see more changes, a lot more, at the NLRB level. What would be interesting from my perspective anyway is, and I think hopefully at some point in time we'll come to a place where we don't get a situation where we have one administration leave and a new administration come in, and then the pendulum swings back and forth every 4 to 8 years, where you have that administration seeking to make changes that are going to really benefit their constituency, And if they're Democrats, their constituency, the people they want, to benefit are going to be the unions. If they're Republicans, the people that want to benefit are going to be the employers. It would be really nice to see a board that comes to an area where they're making decisions that are even keeled and that we don't get this big pendulum swing, because that's what we're getting right now. The Obama board really swung the pendulum one way. Now it's really swinging back basically to where it was before. And so we'll just see. It'll be interesting to see what happens. Okay, onward. So this is our next topic. And our next topic is just employment changes in tax reform law. So there are two significant changes that you may have already, you may already be aware of that for basically HR type changes that would affect what human resources folks are doing. And the first one is that there is now a tax credit for the first 2 weeks of paid family medical leave. And that sounds a little more simple than it is. And there are a lot of questions that, you might be thinking like, oh, what does that mean? Does that mean like that new paid leave that I just had to give my employees because my state just enacted a paid leave law accounts towards that 2 weeks? So essentially, this particular provision says that in order to claim eligible employers in 2018 and 2019, will be able to claim a general business tax credit equal to 12.5% of the amount of wages paid to, and I'm putting this in quotes, this is a term, a very specific term, qualifying employees during any period in which such employees are on family medical leave. The rate of leave must equal 50% of the wages normally paid to an employee. Okay, so the rate that you're providing paid family medical leave, if you're not giving them their full salary, it has to be at least 50%. And then the credit is increased by 25% percentage points, but not above, I should say 0.25 percentage points, but not above 25% for each percentage point by which the rate of paid leave equals 50%. So the tax credit requires that employers have a written policy that allows all qualifying full-time employees, so it doesn't apply to part-time or temp, not less than 2 weeks of annual paid family medical leave. Significant issue, employer-provided vacation, sick, personal, or other medical leave cannot be used as paid leave. So your PTO policy cannot be used to constitute this paid leave. It has to be a separate bank of leave, of paid leave. The policy must also allow, again, quote, qualifying employees, end quote, a commensurate amount of leave on a pro rata basis. So a qualifying employee means any employee who has been employed by an employer for 1 year or more, and for whom, for the preceding year, had compensation not in excess of 60% of the compensation threshold for highly compensated employees. Okay, that was a mouthful. Let's break it down. Basically, a qualifying employee is someone that doesn't earn, is someone that earns mid to lower amount of wages, not high amount of wages. So your executives probably aren't going to be considered qualifying employees. And for example, the 60% of the compensation threshold for highly compensated employees for 2018 is going to mean not in excess of $72,000. So this will apply to full-time employees who who have worked for you in the preceding year for the entire year and who get paid 72 or less per year, okay? And you have to have a written policy, and you have to have a separate leave bank that, you know, for this leave. And also, the leave is only, I believe, for sick, or it's not for like like an employee's serious health condition where they have to go off and get knee surgery. It's only for family medical leave for pregnancy and maternity. So that is a significant thing that you should look into if your company wants to take a tax credit, wants to provide paid leave, and then take the credit for the leave. Maybe it's more of a headache than taking the credit for the leave is worth, because if you do, I would warn you, or just a caveat here, if you do have such a policy and then you don't apply it correctly, then you know there's potentially a claim for failing to provide somebody leave, you know, this paid leave when they should have gotten it. So it's not a requirement. You don't have to do this, but it's something that every company needs to decide for themselves whether they want to do. Okay, the second thing that occurred is in this era of Me Too sex harassment issues, employers cannot write off settlements, and not just for this, and apologize that the slide is a little confusing. It's not write off settlements just for sexual harassment claims. It's that if you settled a sexual harassment claim and your settlement agreement has a confidentiality or a non-disclosure provision in it, then you may not write that off. If you settle a sexual harassment claim and you let the employee go off and text about it and put it on social media and tell the world, then you can write it off. Just a word on the sexual harassment. I'm sure all of you are aware of what's going on nationally and internationally, quite frankly, with respect to sexual harassment. What, you know, as an employment lawyer, and I'm involved in a group, you know, a group of national employment lawyers, and we're discussing this on a blog that we have right now. And one thing we're talking about is, you know, how to make our sexual harassment presentations more interesting, more relevant, you know, and make people listen to them because they've heard them over and over again. And it's like Charlie Brown's teacher in their ear. They're just not listening, right? So how do we make this relevant so that they really understand the significance of sexual harassment in the workplace? And the other thing is that when you have sex, you know, as employers, you really need to be really, really, really doing everything you can to prevent sexual harassment. If, you know, obviously that's a no-brainer, but if you weren't doing that before, you know, the onus is just higher and much higher now, because if you get sued for sexual harassment, and if the case doesn't get dismissed or settled, juries are being very influenced by the Me Too that they're hearing. And it kind of depends on the jury that you get. It always does, right? But we're finding even now that the cases that are coming out in the last year, the awards are much higher and much more punitive than they have been in the past. So it's just, if you haven't done a sexual harassment presentation recently, get out there and do it. I would also say, if you're in a state where gender orientation is protected, make sure your sexual harassment presentation, and also if you work in a place where you have a lot of millennial employees, you know, those employees more and more these days don't think in binary terms with respect to sex. They think of sex as being something that's more fluid. They don't think male, female. So really think about how are you going to incorporate that if, you know, if your workplace is one that has millennials, you know, and has people that think more about sexual orientation as a fluid way. And nowadays, even, young people in college and high school, they object to using the traditional pronouns of him and her. And the pronouns that they want to use are him, her, their, because some people think of themselves as both sexes. So I just put that out as a challenge for you to think about. I just recently did a sexual harassment presentation where one of the managers came up and told me, look, your presentation's out of date. You really need to think about what these millennials are thinking about. They don't understand what you're talking about. And you need to talk in a more fluid way when you're talking about harassment or sexual orientation or sex. So I'm sharing that with you because it was interesting to me, and it's a challenge to me to now come up with a presentation that is going to, provide that. Okay, next, I don't know how many of you are hospitality. I think we'll get through what we have left in our hour. Tip pooling agreement is going to basically affect hospitality folks, and essentially, tip pooling agreements are agreements that employers basically would like to have with their servers and folks that get tips, where they pool the tips and then they distribute them evenly to everybody who's responsible for the customer's experience. So kitchen staff don't normally get tips, but they create the food that the customers eat. And if the food's really great, part of the tip, part of the reason they gave the customer gave a really good tip is because they just had this excellent food. So, and it's not only because they had an excellent server as well. So, that it's that kind of recognition that a lot of restaurant employers would like to see, occur. There's kind of a history into this tip pooling situation. And first you have to understand that the Fair Labor Standards Act has a regulation, and there's something called a tip credit. And so a tip credit is a practice that's allowed by the Fair Labor Standards Act, where the employer can utilize some or all of the employee's tips to assist in providing the employee with a minimum wage payment. So they can pay less than minimum wage and make that up with the tip. If they do that, then the employee has to retain all of their tips. The employer can't take it and then give it back to the employee. So, but this tip credit regulation never talked about what happens if an employer doesn't take a tip credit, because a lot of employers pay full minimum wage and don't take the tip credit. So basically where I sit here in the Ninth Circuit, and I know, for instance, if you are in a place where you are in the 11th Circuit, it's the law there came out basically case came out in 2017 that where the 11th Circuit is doing what the Ninth Circuit used to do, and that is the Ninth Circuit came out with some decisions in 2010 that basically said if an employer doesn't take a tip credit, then they can do tip pooling. They can pool the tips and they can give them out to whoever they want. Well, what ended up happening as a result of that was that some employers gave out tips to, like, I think casinos, this happened in some of the casinos in Las Vegas. They gave out tips to, like, some of the floor managers who didn't, some of the servers or other people didn't really feel like they were really responsible for the customer service. They were managers. And so that created a huge backlash to tip pooling. I think it's not that these people, the servers, wanted just to retain all of their tips themselves or were being selfish and didn't want, say, the food preparers to get it. They just didn't want their managers to get it. So they filed a lawsuit, and that lawsuit ended up overruling the that at the time that lawsuit came out, the DOL also was looking at what was going on with tip pooling, and they issued a regulation in 2011, and that regulation says tips are the property of the employee whether or not the employer has taken a tip credit under the FLSA. So in other words, Doesn't matter whether you take a tip credit, tips are the property of the employee who got them from the customer. The employer is prohibited from using an employee's tips, whether or not it has taken a tip credit, for any reason other than that which is statutorily permitted under the Fair Labor Standards Act. And it says, as a credit against minimum wage, obligations to the employee, or in furtherance of a valid tip pool. So a valid tip pool would be one where it was a tip pool among only those people that customarily get tips. So the back of the house, the kitchen staff don't customarily get tips. So if you shared tips with them, it wasn't a valid tip pool. So this regulation really got a lot of people angry, including the Oregon Restaurant and Lodging Association out here in Oregon, which lodged a complaint against a lawsuit against the tip pooling regulation. And unfortunately, well, for the ORLA, unfortunately, I should say, that case came out. You know, they didn't ultimately end up winning in that case. And so now what's happened is the new DOL that we're seeing, and you know, just as the National Labor Relations Board is changing policies and cases, so will the DOL. And the DOL basically has proposed a new tip pooling regulation. And the request for comments were over, I think, on February 5th. And just the Friday before the request for comments on the new proposed rules came into place, they got hordes and hordes and hordes of comments from basically union representatives, plaintiff type, employers, Democratic Party men, just employees that get tips, saying that this proposed regulation, wasn't fair. So what we've got is sort of we don't know what's happening with respect to the tip pooling regulation. We're going to see what the DOL does. We think they're still going to come out with a new rule that allows greater ability to tip pool, and at least allows tip pooling with folks that don't customarily get tips. But it's kind of in a period of flux right now, so we'll see what happens. Okay, so next thing I want to talk about, I'm going to move through these quickly because we only have another couple of minutes. What we're seeing right now in the last several years is a real increase in employees wanting to be independent contractors rather than regular employees. And a lot of the millennial employees really don't want to get a job where they just go and work for one place for 20 years. They want to get jobs that challenge them in different ways, and they want to move from one company to another. And you see that happening a lot. And then you also see employees just wanting to work on their own and just do what they call gigs. And so this gig economy has really been thriving. And part of that is all of the new kind of ways that people are employing people, for instance, Uber, and Lyft. So, we've got all of that going on. And then we've got the new tax reform that just came out and basically gave, self-employed people the ability to have a pass-through income. And that is also going to affect employees because it's going to be much more lucrative now for them to be independent contractors rather than employees. So I think we're seeing more and more, this happening, and we may see a change in independent contractor. I don't know, the common law has been around for so long, but I know that the Department of Labor came out when Obama was in office with a memorandum that basically said, look, at what matters, there's all these regulations that deal with independent contractors. I mean, every agency has its own regulation, but really what really matters is that employee economically independent? Can they support themselves if they lose this job? And I'm not sure if we'll see a change to that rule, but we are going to see a change to who wants to be independent contractors, and maybe an easing up there. But I would still be very careful in your classification not to misclassify employees as independent contractors, because you could still get cases where employees say, hey, you didn't pay me overtime, or you didn't give me these benefits. So you still have to be careful. I would definitely contact your own attorney on those issues if you're thinking of making any big changes. Okay, so really quickly, the General Data Protection Regulation. This involves, and it applies to all companies that process and hold personal data of data subjects residing in the EU, regardless of where the company is located. So if you're a company that does anything where you get the private information of a resident of the European Union, or you have employees that are in the European Union, you need to pay attention to this. Probably, hopefully you already have. What this regulation does is it basically replaces a former regulation known as the Data Protection Directive, and it creates much stricter data privacy laws with respect to what you can do with private information of an EU resident. And I would definitely, if you're one of, if you think this applies to you, I would contact your IT folks, because that's who is mainly is going to have to really strengthen your processes. Also, HR folks need to strengthen their processes about the private information of employees if they're European Union subjects. But there are some pretty strict penalties that will go along with not complying with this. So it's just heads up. Okay, so this is the last bit that we have. This is on the horizon, and this is not what's happening now, but this is what we can expect. First of all, I don't know if you've seen the news lately, but Obama's budget, or excuse me, Trump's budget is going to severely impact the Department of Labor. It made big cuts to the amount of funds that the Department of Labor gets. So I think we can expect to see a Department of Labor that's not very active because it doesn't have the money to be active. But one question that we have is what's going to happen with that rule that the Department of Labor issued to increase salary levels for exempt employees. As you recall, there was a big to-do where you were going to have to increase it to, 40. I can't even remember what the number was anymore. It was 46,000 or 49,000. But that rule got basically hung up in litigation forever. And one of the issues was the reason it got hung up in litigation is because they said that it was improper only to look at the salary part of the rule and not also the part of the rule that looked at what the work activity that the employee actually did. So that was the real question, I think, that is before the court. The new DOL, head of the DOL, Alexander Acosta, has indicated he wants to revise the rules. So I think we're still going to see a revision, but the increase is going to be much more like $33,000, somewhere about that. That's something that he mentioned. And I think for nonprofits, hopefully, because that was a big deal for the past regulation, nonprofits may be excluded from it. Also, I've talked a little bit about, sexual harassment and what's happening on sexual harassment, but there's a new bill pending before Congress, and you can track it if you want, but it's 2203. It's actually in committee. It was read, and now it's in committee. And this would make a pre-dispute arbitration agreement void as the sexual harassment claim. So if you're an employer that uses arbitration agreements, which I highly recommend, by the way, if you don't have an arbitration agreement, you should definitely ask your attorney if you should have one, because it creates the ability where you're not going to get a big runaway jury on things. However, unfortunately, for sexual harassment claims, if you have a pre-dispute arbitration agreement, then it looks like if this bill gets through then you wouldn't be able to require that employees arbitrate sexual harassment claims. They would have to be tried by a jury, and we know now what juries are doing with those. Juries are going to be very, very strict, and they're looking very strongly at sexual harassment. I mean, the idea is to get a jury, that is made up of people that, aren't going to make an emotional decision. But right now, that's what's happening. So this won't apply if you aren't covered by Title VII. So if you're an employer with less than 15 employees, you can still have a pre-dispute arbitration agreement that would cover sexual harassment claims. And the last thing is that I think that Trump has indicated that he is going to push for creation of a federal paid family leave program that would provide families after the birth. I think I misspoke on the earlier one, got these two things mixed up. So the tax credit would apply to all family leave, but it's this Trump program that would only apply to the birth or adoption of a child within 6 weeks of paid family medical leave. I don't know whether this is going to happen or not, and I don't know whether his budget actually has the money in it to push for creation of this, and it may, if he does do it, it may only apply to federal employees. Obama did that a lot, where he would want to make a change, and the change would just apply to federal employees or to federal contractors. So that's something to keep a lookout for, and we'll see what happens with that. I think that is all I have for you, but there is so much going on out there right now that I'm sure if I were to give this presentation in another month, I would have a whole new hour of topics for you. But I really appreciate your time and attention. Thank you for attending. And if you have any questions, my contact information is there. I'd be happy to answer any questions offline. And have a good rest of the day. Have a good Valentine's Day.
Thank you to everyone who tuned in.